Welcome back to the Big Law Business Report, where big law meets big business. In the studio today with me is Phill Hampton with the law firm of Haynes Boone. Phil's an intellectual property attorney. Phill, thanks so much for joining me.
Well, thank you for having me, Ron.
All right, so Phill, you and I have had numerous conversations in and around intellectual property and how you work with your clients, and you talk about something about the Supreme Court, in some of the conversations that we had. What was that all about, Phill?
Oh, I mean, it's one of the things I always try to impress upon a client, and that is, yes, you want to win. Yes, you want to be aggressive in pursuing your claims, but you never want to be so aggressive or take such an outlying position such that your case ends up at the Supreme Court. Because generally speaking, if your case ends up at the Supreme Court, you've spent millions of dollars just to get it there.
Right.
And I know very few clients that like to have a Supreme Court case named after them. Because
particularly when they may not have prevailed in.
And especially if they don't prevail, but even if you prevail. And that's the other thing I always tell clients is, let's not be afraid to litigate. Sometimes your opposition forces you to litigate.
Right.
But don't look at litigation as your first option, because at the end of the day, you're going to be less than 100% happy with me because you've spent $2 to $3 million
Sure.
with me. So that usually means that almost all that money could have gone into your pocket if we could have come up with a non-litigated solution to your problem.
Right. So talk a little bit about some scenarios where you created non-litigation solutions for your clients. Obviously, you can't mention client names. I'm not looking for that. I'm just kind of understanding the scenarios and some of the things that you've done.
Well, I mean, on the patent side, you can often counsel your client to look for holistic solutions, to look for win-win solutions. You can come up with creative licensing arrangements. I mean, a license is probably one of the best things to do because you can set your own terms. You can say that you can geographically divide up where a patent can be used. You can, do it based on time. You can say, okay, for 3 years you can do this, or for 5 years you can do this, but you can't do it in Louisiana, but you can do it in Texas, that sort
Right.
of thing. So that helps get people off of the hard and fast positions, because there can be some give and take in licensing agreements. And trademarks are the same way. I mean, trademarks, you're dealing with brands, and whether or not two brands are too similar or not similar enough.
Right.
So, and the other thing that's become very important on the trademark side is social media. I now tell bigger clients to be very careful in sending demand letters to a smaller company, particularly if you're stretching the bounds of trademark law, because you don't want your demand letter to be posted on the internet by the small company and then allow all this bad publicity about how you're trying to bully a small client. So you have to be very careful, and you have to really learn not only what your client does, but you also have to learn their industry. What it is what are the industry norms? I mean, years ago, I did a lot of work in the dry cell battery business.
Sure.
And for almost 50 years, there was never a lawsuit in that industry.
Wow.
The big players would respect each other's patents. So people are getting patents on very minor inventions. But think about it, if there was 1 billion dry cell batteries made and your invention saves you 3 cents,
Sure.
3 cents times 1 billion actually starts talking about real money.
That's right, absolutely.
So there were those sorts of things. So there's certain industries where everyone respects one another, and they actually, although they know what everyone else is doing, and there are other industries where people go rogue immediately and decide. I mean, one thing that's changed is the speed of technology changing.
Right.
And something like dry cell batteries, it took years and years and years for there to be a major change. And things like cell phones is almost overnight.
Sure.
So often now in the cell phone wars, you had, especially when you went from 3G to 4G,
Right.
everybody was suing each other to get an advantage.
Sure, sure. So let's just touch on the cell phone thing for example, for just for a second. So you're saying everybody was suing each other trying to get an advantage. What exactly were they going after each other over? Was it patent infringements? I mean, what was going on? I mean, to me, it seems like the cell phones, the smartphones, all pretty much behave the same way. I guess as far as technology is concerned, maybe they don't.
They really don't. I mean, there were things involving things as minor as how do you get a ringtone to operate in a certain way. There were ringtones. There were how do you manipulate certain data? How do you go to how do you connect a 4G phone to a 3G network? There were a lot of different things, and that's why there were so many. And a lot of those cases were actually filed in the International Trade Commission because there were a lot of foreign manufacturers, most cell phones, even Apple phones.
Right.
Apple was sued in the International Trade Commission by Samsung because Samsung had U.S. patents, and they claimed that Apple, which was putting its phones together overseas, was possibly infringing a United States patent.
Wow, that's amazing. That's simply amazing. It would have. I mean, when one thinks about, it's almost a little bit ironic. Excuse me. It's almost a little bit ironic because when I think about Samsung as being an overseas foreign company and Apple being the American company, would almost see it as the other way around.
But it's not not whether or not you're a foreign company. It's whether or not you have a U.S. patent, and whether or not you have a quote domestic industry, and that domestic industry can be a licensing plan. So in that situation, Samsung had U.S. patents, and it had a whole licensing regime, which could count as a domestic industry.
Wow.
So even though Apple is in Cupertino, they were actually importing the devices into the United States.
Wow, that's amazing. So Phil, how do you advise your clients on these things? I got a funny feeling that's probably another conversation for another time and another day.
Well, how, again, you have to really understand the business and understand what your client wants as the end result.
Gotcha.
Do they want to have just market share, or are they money? I mean, the two things are sometimes different.
Sure, no doubt. Well, Phil, as usual, we never have enough time to talk about all the fascinating things that you do. But as I always like to say to my guests, I'm not asking you to come back. I'm sort of telling you to come back. We'll definitely have you back on the show again. Phil, thank you so much for your time today.
Thanks again, Brian.
All right. We'll be right back.